9 o'clock, and we are going to start with our first meeting of the Budget Review Subcommittee on Economic Development, Tourism, and Environmental Protection. And Madam Secretary, would you call the roll?
Senator Harper Angel, Senator Smith, Representative All,
Here.
Representative Bray, Representative Gentry, Representative Hart, Representative Lockett, Senator Bledsoe, Representative Reed, Representative Weber, Senator Boswell, Chair Fugate.
Here. And thank you all for coming. Hope your summer's going good, and thank God for the rain on the way up here this morning. We need some rain back home. But today we have Kent Chandler here from the Public Service Commission, going to present an overview of the commission and legislation that we passed on last session. If you'd come to the table. When you get to the table, raise your right hand. We'll swear you in. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you, Mr. Chandler. You may begin your testimony.
Yeah. Thanks, Representative Fugate. And I always say to myself at the PSC, we swear people in. My goal in life was always to be the person asking the questions and never being the person that having to answer. But here we are anyways.
I got swore in for 22 years in courts all across Kentucky, so nothing to it, right?
That's right. So thank you all for having me today. I'm prepared to talk today just a general overview of the PSC, especially as it relates to budget and appropriations, and then talk a little bit about what we've done with what we have, trying to look at ways to do new things or look at regulation that makes sense for end-use consumers. And then at the end of the presentation, pivot to at least a few of the bills that were passed this last session that impact the Public Service Commission or that we're expected to hold folks accountable to. So the Public Service Commission is a 3-person administrative agency that's independent. We're attached to the Energy and Environment Cabinet for administrative purposes. We say we do a quasi-judicial function. There's a lot of case law out there about how we do what we do, but we do a little bit of legislative work. Actually, setting rates is a legislative function. And then insofar as there are complaints or adjudicative matters, we act sort of like a court where it's actually one person versus one entity versus another entity. But we do it. We sit and have hearings, take evidence, and then we ultimately issue our decisions in written orders. When I get to written orders, I always have to go back to what was on the first page. My presentation today, I can only speak for myself, not on behalf of the other commissioners or the commission itself. The commission can only take actions that are worth any salt on the 4 corners of an order. So if I say something that contradicts what we've said in an order, the order is what actually matters. So we set the rates and regulate the service of over 1,000 utilities across the country or across the state. We have a lot of water and sewer systems. We have approximately 150, 160 water and sewer systems. The majority of those are water districts that are subdivisions of counties. We regulate natural gas distribution systems and intrastate pipelines. Interstate pipelines are regulated at the federal level. We regulate electric utilities, both investor-owned utilities as well as electric cooperatives. And then we regulate a number of telecommunications. I put small number on here because the actual number of utilities that we regulate for the rates and service is fairly small, but we do have some minimal oversight over a number of cellular options. And the number of folks that fall into that category are about 250 or 300 entities, which is why our number is actually over 1,000. I'd say we heavily is not the right term. We really regulate probably about 250 utilities on an active basis. Importantly, we don't regulate municipal utilities except for 2 specific items. First is for gas safety. We regulate those gas distribution systems for their compliance with federal law. We also regulate the interaction between municipal water systems and water systems that we regulate. So if a city water system sells water to a water district, we regulate the rate in which they can sell to that water district. And then finally, there are a number of electric distribution cooperatives in the southern part of the state that buy their power from the Tennessee Valley Authority. Those rates are regulated by TVA effectively, and therefore we don't regulate those electric cooperatives. So the Public Service Commission was created in the 30s. Everything that we do comes back to one of our primary statutes, which is that a utility can only charge rates that are fair, just, and reasonable, but a utility also has an obligation to provide adequate, efficient, and reasonable service. Almost everything that we do ends up coming back to either a rates or service issue, and whether either one of those are in accordance with the statutory requirements. So we've had a good amount of turnover on the commission since 2021. I'm beginning to think it's me. We've had 2 commissioners that left in 2021. We had 2 appointments in 2021 to replace them. Those commissioners went off in the spring of 2022. We got another appointment about 11 months ago, and then we got our 3rd appointment to the commission in, I believe, February or March. Both of those individuals were confirmed in the last session, and so we've got 3 commissioners that are all confirmed for the first time in a while. So that's really nice. The PSC has about half the employees that we had 20 years ago. We enter significantly more orders than we did a few years ago. Like I said, we can't take any action other than an order. So orders are there's a pretty direct correlation between the amount of work we have in front of us and the amount of orders that we issue. We've had a complete turnover in the entirety of our management and the financial division of the Public Service Commission. Those are the people that, frankly, have the most experience with regards to accounting, economics, finance for our utilities. Our annual turnover for attorneys is between 20 and 35%. I think this last year it was actually closer to 40% with the numbers I've seen. But it's at least 20 to 35% over the last 3 or 4 years, where once they come in, they may be there for a year, year and a half, and then they leave. That has effectively required us to have more attorneys than we had in the past, just because we know we're going to have the constant turnover. When I came into the industry, I was told that figuring out what the Public Service Commission did is a 2 to 3 year learning curve. So you can imagine if we're that 20 to 35% includes attorneys that we've had at the commission for 20 years. So you can imagine what that low end of the average looks like. And we have a lot of attorneys that just about the time they're getting up fully to speed to figure out what they're doing, they're taking a job somewhere else. I have a couple of statistics that I asked for and pulled ahead of this. That in 2021 and in 2022, we issued hundreds of more orders than we did about 15 years ago. We issued about 1,770 orders the last couple of years. For instance, in over the past 15 years, the most, other than those 2 years we've ever entered, is 1,500, and the minimum we've entered in over those 15 years is 1,200. So at least with one of those, it's almost a 30% increase. In 2021, the Public Service Commission processed more utility-initiated rate cases than any single year in the last decade. In 2021, when we did that, we had 69 employees at the commission. In the 10 years before that, was the second most number of rate cases that we had processed, and we had 96 employees. So a 25 employee difference. We have 72 employees today. We have 2 or 3 that are starting in June. Of the 72 that we have today, they are about 30%. No, they're about 50% less experienced than the 96 employees we had in 2011. In 2011, our average months of service was something like 10 years, or months of service something like 12,000. Our average months of service for our employees at the end of May was something like 8,500. So that's 6 or 7 years. And that was skewed because we had somebody retire on the end of May that had 37 years experience at the Public Service Commission. So that number is going to go down significantly when we add 2 new people with no experience at all next month. The average, so between 2000 and I'm going from memory here, Chairman, so you'll excuse me if I maybe get it a couple of dollars off wrong. In 2006, our average position cost to fill a position was about $71,000. Today, to fill the average position, it's about $136,000. That cost is in significant part due to the change in the retirement rate. It used to be about 5.5%, 6%. Now, in the last year that we have full data for, it was in the upper 80s or mid 80s. So we had less people, but it cost more people to have. So between 2006 and 2022, our general fund appropriation was effectively flat. Somewhere it ranged every single year, but somewhere between $8.5 million and $10.5 million. Very thankfully, in this last budget in 2022, we got significantly more general fund appropriation than we had basically ever had, and increased our budget by maybe $1.5 million over what it was the previous year, maybe closer to $2 million. And that's allowed us to fund 8 new positions at the Public Service Commission. So we're certainly appreciative of that. I know the other employees are, that there's more shoulders to spread work out over. So where we, for years, did not have a ton of resources, or we had declining resources and we had to figure out to do things differently, we did try to do our best to work smarter and harder because we knew we had less opportunity or less resources to address the issues that came before us. So we really went under a number of internal reviews of processes. One of the things the PSC did years ago was actually move by agreement with the cabinet, we moved our engineers to the cabinet. And that way we would have more cap space for the attorneys and the financial folks that we needed to process the cases that we have more quickly. And then trying to use technology. Actually, we require through regulations a lot of information from utilities. Over the years, there have just been less and less people to look at that information. So we've started to try to mine that automatically so that, for instance, we can see if a utility if a water district is losing money 2 or 3 years in a row, we will get that information automatically, and then we can go out and we can speak to the water district, or we can try to, make them come in to make sure that they have adequate rates. Because if they have inadequate rates for long enough and they're constantly losing money, then customers are going to get poor service over time. So we identified we've got to have something has to change because we're getting, if not more cases, certainly more complex cases. So even if the cases stay the same, I can tell you right now, one of the cases that we have in front of us is probably the most consequential and complicated case the PSC has had in the history that I can find. So let's call it 35, 40 years. So we need people with a lot of technical skills. We need to reduce the turnover of the people that we have, because by the time they figure out what's going on, they get really good at their job. They can go make money somewhere, better money, or have an easier job somewhere else. We also, in addition to technical skills, we have to focus more on wholesale issues. A lot of the stuff that happens, and you all hear this, it's most public with rules that get passed by the EPA, right? Certain things that happen at the federal level, there's not much that we can do at the state level. That's also the case for rates and services when it comes to utilities, because many of the rates and charges that our utilities incur are actually set by a federal agency that does something very similar to us. And once that federal agency sets those rates, there's effectively nothing we can do keeping those from going back to customers. And so we've engaged more and more actively at the federal level so that we can be at the table, because it really does come down to the old saying that if you're not at the table, you're on the menu. That if we're not in the room when these decisions are being made at the federal level, it's likely going to result in increased costs for consumers that they can't avoid here at the retail level. So a couple of things that we've done over the past or are doing is we've opened an investigation of the fuel adjustment clause. In 2020, in the 2022 session, the Senate passed a resolution asking the commission to review the fuel adjustment clause. The fuel adjustment clause regulation itself has been in effect for 40 years. It's barely been changed in that entire 40-year period. It existed prior to that. It was in the utilities tariffs for decades before that. The fuel adjustment clause is a clause that's included in the tariffs of electric utilities that allows electric utilities to reflect through a line item on customers' bills the increase or decrease in fuel and purchase power costs compared to a baseline level that they were already recovering. So, for instance, if a utility has to go out and buy a bunch of coal or gas and it's more expensive than what they have are already recovering, they're able 2 months after incurring that cost to pass that through to customers. Same thing, if they go out and purchase fuel that's less than what they had, then they actually can create a savings. Or if they were able to participate in a wholesale power market and make money out of that wholesale power market, they can actually be passing a credit back to customers. So fuel costs make up a very, very large amount of end-use customers' electric bills. Just to provide you an example, I pulled that in 2021, Kentucky Utilities, which is our largest utility, that they had approximately $1.64 billion in retail sales, which equates to about $1.64 billion in costs. That's a pretty equal comparison. Of that, almost a third of it were fuel costs. So imagine that for every $100 bill that a customer gets, about $30 of it ends up being fuel expenses. And almost all of the significant amount of that fuel expenses, or at least the increment or decrement to it, is being passed through on that single line item pursuant to a 40-year-old regulation. And as we noted, as a lot of us saw through 2020, 2021, and 2022, demand for electricity went really, really down in 2020. Power prices were very, very low. The opposite happened in 2021. Demand went way up, and there were very little... Demand went up much faster than supply could meet it, and power prices were at 10 and 15-year highs in 2021 and 2022, excuse me. So those fluctuations by default show up in that fuel adjustment clause line item. So the commission, when opening the investigation, asked a number of questions, including what changes to the regulation, if any, could reduce the monthly volatility of customer bills. What changes to the regulation, if any, could reduce exposure of the actual utility to volatility in wholesale power markets? And then how does the current structure of the regulation affect the efficiency and reliability of power plants? There's some question that if a utility is able to buy power from the market and pass it through to consumers without any regard for what the cost of that power is, then what interest of the utility is there to make sure that they're maintaining their power plants to run as opposed to just depending on the markets? So these are the types of questions that we're asking. Hopefully we can get an answer by the end of the year. Commenters varied: utilities, public interest groups, the Attorney General's office, industrial groups, suggested a number of amendments, including cost sharing, levelizing different charges as opposed to it being up and down, maybe like an average, and then stricter review of purchases by utilities. So the case is open and pending. I just wanted to talk about some of the objective things that have been said in that. I can't really comment on anything beyond that, but I wanted to make sure that you all knew it was going on, and that at any time, if you are individually interested, it's still open if anybody would like to file a comment in it. So regulating utilities at base is really about, and this is my personal worldview. I don't know that anybody's put this down in a textbook, but it's really about regulating utility incentives. So utilities in Kentucky are not competitive businesses, but as I mentioned earlier, actually have their rates and their services regulated. They can't charge more than what they're approved to charge. Historically, there was a concern around the duplication of the same service. So two different electric companies want to serve a single site, running two different sets of lines to that home. That's wasteful duplication is what the legislature effectively decided. That you only need one set of wires to be running to the home, and we only have a limited amount of capital available in the economy to make all the investments we need. We don't need to be wasting that running multiple lines to homes, multiple pipes to homes. And so the fix to that was to give utilities monopolies, or effectively monopolies. The issue with giving utilities monopolies is twofold. The first is that once somebody knows somebody is their customer for eternity, there's not much interest in actually meeting quality standards because there's nowhere else for that customer to go. So the first risk of a monopoly is a risk of poor service. The second is that the monopoly charges rates or charges prices in excess of the cost that they incur. And so the solution that the legislature came up with in the 1930s is let's regulate their rates and regulate their service, hold them accountable for how much they can charge and the minimum level of service that they provide. So the rate setting is a function of costs. When we set a utility's rates, we figure up what we think the costs to serve are going to be, and then we turn those into rates to charge customers. That is as high level as the rate making process can be. I promise you, I wish it wasn't, but it's a bit more difficult than I may have made it sound. But so since we, society, have a concern about the prices that a monopoly would charge, including that IOUs could charge rates in excess of their costs, or even, and this is actually far more common, that publicly owned utilities would charge rates that are below their costs and lose money. Rates are based on the actual cost incurred or expected to be incurred. And the thing to think about that is we can take, when we're setting rates, we can look back and see what a utility actually incurred, the cost they incurred, and we can use that to set rates going forward. But it also is a matter of judgment for the commission in saying that if a utility incurred costs that we don't think was reasonable. A perfect example is country club dues. We've had in our regulations for years that utilities can't recover from customers the cost of country club and social dues. That's a cost that historically they did incur and did try to pass through to ratepayers. So by default, we remove that when we set rates going forward. So it's not just did they incur the cost, it's was it a reasonable cost for them to recover from customers going forward. So different entities have different incentives. I mentioned it earlier. The big distinction is for-profit utilities versus not-for-profit utilities. For-profit utilities, by definition, have a profit motive. Their goal as a for-profit firm is to maximize shareholder value. Customer-owned entities have a motive to keep costs low and often keep costs too low to the point that it actually degrades service. We find that in water districts that have no interest or historically don't want to recover depreciation expense so that the depreciation expense is then available to reinvest in their own systems. And we find that most often with the electric distribution cooperatives where historically the place to find savings so that they can make it year to year is to just not incur vegetation management expenses, is to just cut less trees around power lines. The problem with that is you neglect the trees around power lines for a couple of years, and you're going to have an increase in power outages. And it's not just a degradation of service. What I've found is that neglect actually leads to higher rates in the long term for two reasons. The first is when you have power outages, you have to send people out. You have to send trucks out to actually fix the power outage. That's incurring additional costs that you were not anticipating. The second is it's going to cost more to catch up on your vegetation management if you've neglected it over a number of years than to just do a minimal amount each year. And so it's one of those, trying to save money today ends up costing you more in the long run. So in acknowledgement that different entities do have different governance structures and therefore incentives, we've done a couple of things to try to approach each type of utility a little bit differently. So the first is the the water districts. We had an investigation right when I was coming to the commission. It was ending, but following that investigation, it was an investigation into the utilities, the dozen or so utilities in the state that had the highest water loss. And some of these utilities were only selling about 20% of the water that they were producing for sale. That following that investigation, the commission placed a greater emphasis on ensuring that rural water districts had sufficient revenues to address their aging systems, the water loss issues they had, and other problems that ultimately degrade service. And so we started instituting defined, transparent surcharges that the utility can only use to address water loss. And so they have to come to us with a water loss reduction plan. They have to seek explicit commission approval before they actually spend the money. But it's a line item on customers' bills that customers have. There's a transparency and appreciation, I think, that they know when they pay that bit of extra money that month, it's going directly into making sure that the system gets better and that reduces water loss, which is a recurring cost that ultimately is ultimately going to be passed through to customers anyways. The other acknowledgement and sort of change in regulation was that the rural electric cooperatives, we created a pilot streamlined process to incentivize smaller but more frequent rate cases by the rural electric cooperatives. The majority of costs that our co-ops charge are actually passed on from Big Rivers and East Kentucky Power. There are a limited number of cost drivers that are under their control. Depreciation, employee wages, and vegetation management are the big three. One of those three, vegetation management, I've already explained why not having enough money to do it is ultimately bad. And so we created this streamlined process to increase the frequency of rate cases. While reducing the size of the increases, it should actually reduce the cost to the utility in bringing each one of those rate cases. And just throw out there, and I'm going to skip ahead to the bills passed in this last session, but just throw out there that investor-owned utilities make more the more that they invest. So they have an incentive to invest more and more between rate cases. Rural electric cooperatives just need rates that are low enough, or just need rates high enough so that they can pay off their debt. That's it. That's their only incentive. And so because they don't have an incentive to maximize investments between rate cases, it only makes sense to bring them more often in for rate cases. Just a couple of things. We're working on an overhaul of our regulations. We actually started it at the outset of COVID and then realized that we didn't have the resources to see it through. We'll be starting that up hopefully again this year with the additional employees that we have. We're going to take our streamlined process that we came up with by rule by order and codified in regulation. And then we've talked publicly that our integrated resource plan regulation needs to be overhauled. The integrated resource plan is a triennial plan that utilities come in and tell us electric utilities come in and tell us how they're going to meet their future customers' demand, what kind of generation they're going to have, what kind of demand do they think they're going to have from customers. The IRPs have not been good enough. That's the way to say it. We can do better. We can ask more questions. The commission can ask more questions. The utilities can ask more questions of themselves. But we need to spend more time and more effort on making sure that we have an adequate amount of resources at any given hour to meet customers' demands for a 15-year period. And we need to make sure that we're not just going through a routine planning exercise and then not doing what we said we were going to do, or not being adequately prepared for what's on the horizon. So in this past session, three bills I want to bring up that do impact the Public Service Commission. The first is Senate Bill 4, related to the retirement of fossil fuel-fired generators. It had an emergency clause, so the case is already, or the law, excuse me, it's not a bill anymore, right? The law is already in effect. And we are actually processing our first case under the law, and I'll come back to Senate Bill 4 in a second. There was Senate Bill 192 that's related to securitization. It goes into effect later this month. And then there was House Bill 4 related to merchant solar, and it also goes into effect later this month. I don't have much on House Bill 4, so I'll start there. The Public Service Commission does not regulate merchant transmission and merchant generation the way that, at all. But merchant transmission and merchant generation is not regulated the same way that utilities are regulated. About 20 years ago, the legislature created, I think it's called the Kentucky State Board on Electric Generation and Transmission Siting. We just call it the Siting Board. Calling it a board is a misnomer. A board is actually created each and every time an application is filed. There are right now like 20 boards, 15 boards. There are always lots of boards. But each time one of these siting boards is constituted, it has 7 members on it. There's the 3 members of the Public Service Commission, the Secretary of the Energy and Environment Cabinet, Secretary for the Cabinet for Economic Development, and then 2 local members, one of which is appointed by the governor, and the other one is either the chair of the Planning and Zoning Commission or the judge executive, depending on whether they have a Planning and Zoning Commission. I bring this up, and you may say, well, you're on a board. How does that impact the PSC? The siting board is actually situated with the Public Service Commission. Our staffs the Public Service Commission. The cases for the siting board are all filed on our website. We use all of our technology to process them. We have to hire consultants. The statute allows us to hire consultants to process those cases. The PSC actually puts those RFPs out and chooses those consultants ahead of time. So really, we make the siting board run, and then those other 4 people are added to each case that the siting board runs. But insofar as there are no siting board cases, then there is no impact on our budget. I will say the majority of the cost the vast majority of the cost to process those siting board cases are recovered from the applicants. It's a requirement in the statute. But There are a lot of costs, especially overhead costs and time and effort and things like that, that necessarily just can't be passed through as a dollar amount. And so this influx of merchant cases that we've gotten has really taken a toll on our resources at the exact same time that we have the least amount of resources that we've had. I think, Chairman, I think we've probably processed before 2000, maybe, I'm going from memory here, 10 or 12, sounds about right, merchant cases ever. We've received over 30, I think more than 35 now, notices or actually applications since 2020 for these merchant cases. So it has been a tsunami is a good word. So I'll talk about Senate Bill 4 just for a second. Senate Bill 4 was put into is in effect. It's now codified as 278-264, I think, and it requires. It's the first time that I'm aware of that the law explicitly requires that a utility seek commission approval before a utility retires a power plant. In the past, a utility could retire a power plant and not have to get commission approval to do so. The only time that the commission would be brought into it is if the power plant had value left on it that had not been recovered yet. And if the utility wanted to recover that undepreciated value from customers, they'd have to come and seek commission approval to do that, either through a line item or put it into rates, whatever it may be. It's kind of I explained it once as the commission did not historically make the decision on retirement. We just told the utility what the economic consequence of their decision was. It's different now. The statute provides a standard that the commission has to apply to making sure that if a utility retires a fossil fuel-fired power plant or a number of power plants, that it does not net impact the reliability, resilience, and dispatchability of the utility system. Kentucky Utilities has already filed a case under this. They had a case in front of us for additions of generation that were in large part required because they were planning on retiring things, and so they effectively amended. They didn't exactly, but they effectively amended their application to now include the request to retire generators, and so that's in a case in front of us right now. And then Senate Bill 192 was related to securitization. I'll give you the simple securitization because I understand about 70% of it. Securitization is a process that a state can set up by statute that would allow customers of a utility to effectively buy an asset from the utility using money provided by bonds financed by lenders. So it's often called, securitization bonds are often called ratepayer-backed bonds, but the practical effect is that the consumers are financing a cost as opposed to the utility financing a cost. The benefit of that is that utilities have both equity and debt capital, and equity capital requires a higher return than debt because debt holders get the first call on the utility's assets should it go under, or any company's assets should it go under. And so because debt costs less than equity capital, if you're effectively just replacing you're replacing financing that had debt at a certain rate and equity at a significantly higher rate to just having debt at the low rate. And that's the benefit of securitization. It's not just any regular debt. I'm really skipping here, but it's not just any regular debt. It's actually because of the way that the statutes are written, almost without exception, the bonds that are issued for securitization under states' statutory schemes are almost always given AAA ratings. And because they're rated so high, they have the absolute lowest debt rate that you can get. Importantly, the debt, although it's issued effectively pursuant to statute, it is not a... I really want to find that. It is not a debt of the Commonwealth. The Commonwealth's effectively saying, we will make sure that the customers of this utility pay this debt off, but it is not an obligation of the state that allows for securitization. So there have been numbers thrown around that if a particular utility, and I think it was referred to in the testimony, I don't know these numbers for a fact, Chairman, so I'm just telling you what I heard. But Senator Wheeler, when he was talking about Senate Bill 192, mentioned that if the Big Sandy retirement, it's not the Big Sandy retirement rider, the Big Sandy decommissioning rider, if it was securitized, it would lead to, at prevailing debt rates today, it would lead to millions of dollars of savings per year. That is an objective fact. That if it was financed at a rate that only included debt and had no equity return, that would save millions, if not, I think a fair back of the napkin, 8 to 10, maybe $12 million a year, depending on whatever the prevailing debt rates are at the time that it would be securitized. That is the only facility that I've heard actively being discussed or publicly being discussed that is intended to be securitized under Senate Bill 192 when it does go into effect. As it relates to the PSC, I don't expect there to be much change from House Bill 4 on our budget or on our operations. As it relates to the PSC, it's really changes kind of around the margins. There has been a significant impact from these merchant facilities on our resources, but I don't expect the law to change anything in that regard. With Senate Bill 192, it allows the Public Service Commission to go out and get experts and then pass those off to be included in the amount that's securitized. I don't expect that to be a significant cost. If there are only one or two securitizations done every few years, I don't expect there to be a significant impact. Long term, though, I think it's important, though, that we have people and we are able to retain people so that from one proposal for securitization to the next, that we have some people there that have had some knowledge and experience with doing it. It would be really, really difficult if the people that we have there are new every single time that we have one of these securitization processes. And then in terms of the impact of Senate Bill 4. Senate Bill 4 does require a significant amount of, how do I say this? Whether or not a retirement and addition of generation, especially when you're doing multiple retirements and multiple additions of generation at the same time, is an incredibly complicated technical process. We had, call it luck, call it foresight, I don't know. Thankfully, we had some consultants that we already had that responded to an RFP that we had on contract already in case, in the event a case like this came up. But for their technical expertise, a case under Senate Bill 4, we would be very dependent on the information that we receive from the utility and that we receive from the handful of interveners in that case. We would not have necessarily the technical ability to determine on our own or to probe the integrity of the information that we get as to whether or not the proposal actually does have a negative impact on reliability, a negative impact on dispatchability, or a negative impact on resilience. I, about a week ago, sat back and thought to myself, I don't know what we would have done if it wasn't that we already had these technical experts on contract. We do not have that technical expertise in-house. Historically, we had it, but the way things have gone the last 20, 30 years, we don't have it anymore. So that I just want to give you the high-level overview. I hope that's been responsive to what you were hoping I was talking about today, and happy to answer any questions.
Okay, thank you, sir. We do have some questions. Senator Smith?
Yes, Mr. Chandler, it's good to have you with us. I appreciate your coming in front of the committee and the work that you are doing at the Public Service Commission. I think most of us realize in Eastern Kentucky that for years to bring economic development, we would do the spec buildings. That was sort of our way. We build it, they'll come sort of attitude. And that worked for us in Perry County on several occasions with DJ Plastics, Trust Joyce McMillan, Haas Industries. A lot of different groups came in there because we had the facilities for them. But that's changed now. And what you see in these industrial parks are people come in and they want to know one thing: how much is the power rate? More so than anything we've ever seen. I don't know that I've ever seen a time that power became such an economic development tool as it is now. And if you went out there and told industry across the United States, even across the globe, that you could guarantee them a 5-year rate of 3 and 4 cents power below 6, we would fill up these industrial parks. I mean, that's how important it is for the power rate for what's happening across America and many other countries. Is that power is one of the key economic driving forces that we've ever seen. The buildings are secondary. A lot of times they don't even ask about it. They don't care as they stand out there, because without that power rate being affordable, and the tech industry and many other industries, you're not going to be here regardless. So we know that the job that you all do is critical for all of us. And as we look at what's happening to us, the economic development rider is critical for us to have to create industry there. But also, as they decommissioned the plant in Big Sandy, that created a unlevel playing field for a lot of us there, because we're hit with that 12 to 15 cent increase that's put across everyone's bills to make up for that. And that's something that, as industry comes into Eastern Kentucky and they look at our bills and say, why are you so much higher? And we're trying to explain to them that we were basically forced into decommissioning a plant, and now that cost is being spread out across people. That puts us again at another disadvantage. So it creates another economic hurdle at a time that, as we've just discussed, power is critical for industry. So that's something that I think is the General Assembly that we really need to take a look at. This happened to us because federal pressure on the industry, and they responded, and now we're stuck with this mess out there. And I really think that the federal government should play some role in coming in to help us mitigate these costs. And that's what you all are over there struggling with right now, with all the different ways of trying to take care of these high and lows and the troughs and peaks to make it more affordable for the people that we serve. And of course, this is more of a commentary than a question, but we're seeing an industry, or as far as power, in a way we've never seen it before. We're seeing rolling blackouts now. They're becoming very, very common. And we've seen some of the letters and natural resources that were passed out to industry telling them, you're going to be without power so many hours a day, but the good news is you can pick when these hours are going to come. That's not the I never dreamed of Kentucky, with the rich history that we have and the ability to providing energy and all the natural resources that we have, that we wind up like a banana republic, being power poor. And that's exactly what's getting ready to happen. And that's happening not because the men and women are not willing to go out there and provide the natural resources that we need. That's all bad government. This is all being created by leadership that has a lack of understanding and what's happening in the world of energy and economic development, and how Kentucky plays a role. So this is something that we can fix. It's not always been the case, but I think that we've got some really sharp people that are taking a look at this. But Kentucky should be leading the way. And I think Senate President Stivers had mentioned last year that we can have such a huge impact if our hands are untied, that we could actually affect the national market as well by letting Kentucky do what we do very, very well. And that's get rid of a lot of the bureaucracy, get our permits that we're sitting on right now that we can't get into the mine, the coal, and other assets that we have for coal and gas, because we can't get the permitting process to work with us. So we're sitting here just getting pummeled. And I think that falls back on us as members of the General Assembly. You've done an amazing job over there, and you've taken every call that I've had, which is a neat change for the precedent before, that as chairman and members of the General Assembly, as we've reached out to the cabinet and agencies, you are advised often, don't go over there. And it's probably a pretty smart bet, but you have really been different as far as your leadership of the Public Service Commission. I want to commend you, because it's not always been the case. As members of the General Assembly, we've not had this type of access to the type of leadership for these different agencies. And I want to point that out. That's markedly different than what I've seen in my tenure here. I think it's been wonderful, because the exchange between all of us has been very productive. And just wanted to comment on you how much I appreciate that as a senator, but also as a chairman that has to work with you all quite often. But that's something that is very different from the past. But with that said, we have a lot of work to do.
Yeah.
And I appreciate the leadership you've had over there. There's things that we can do, things that we can't do, but a lot of the stuff that's holding Kentucky back is literally decisions that need to be made at our leadership. So with that said, thank you for coming today, and appreciate the chairman giving us an opportunity to speak to the Public Service Commission.
Thanks, Senator Smith. Representative Lockett.
Thank you, Mr. Chairman. I just had a quick question First, I want to say thank you for being here. I appreciate the information that you shared. You talked earlier in your presentation about kind of the turnover of staff and looking at I think you quoted within the last year, the last 2 years, there's been a 100% turnover in the financial division. Can you speak to, and maybe this is partly opinion on your part, but can you speak to why that would be the case? What type of qualifications are needed in that division, and then why do you feel like there is a 100% turnover rate?
Yeah, and so to be clear, it's a 100% turnover rate in the management of that division. So that would be 3 or 4 people. But those are the 3 or 4 people that know the absolute most about what we do, about the financing, the economics, the accounting of utilities. And some of you all may know like GAAP, the generally accepted accounting principles. GAAP applies to these utilities, and then they have a entirely separate accounting system exclusive to utilities called the Uniform System of Accounts. So we have people in-house that we get a CPA and they go, okay, that's great, but all of this is new to me. Like I could be a 20-year CPA and this entire accounting is completely different. It is just such a unique skill set and unique experience that effectively you either get it at a commission or you get it at a utility, and there is nowhere else that you can get this type of experience. We've had one person that previously worked at KIA that dealt with utilities, that was a experience at KIA was applicable at the Public Service Commission. I'll speak generally so that I'm not too specific about any of the individuals. But these individuals have skill sets that if they took that skill set to a utility, whether they're in Kentucky or somewhere else, and it's very applicable to other states. I mean, all 50 states use the same thing. These people would easily make 2 or 3 times as much as they do at the Public Service Commission with the skill set that they have. That is a significant amount of it. I think that's a large driver of it is the fact that we have people that leave that make 50% more, 70% more, or double or triple their salary if they go and work, I'll say, in the industry. And that has been a big driver of our turnover. We have tried, in large part, to address the turnover issue since, thankfully, we got a larger general fund appropriation by raising a significant number of salaries across the financial analysis division as well as our legal division. That has helped to a certain degree of keeping the people that we have. We are really struggling now to find people with degrees in economics and finance and accounting that directly out of school want to come and work at our entry-level positions at the Public Service Commission. And so we've internally over the last couple of weeks actually taken steps. We're reaching out to the business schools in the state to speak directly to the folks that they have that let their recent graduates know about job openings. But we're finding, this is pretty consistent. We're taking applications. Maybe we'll put out a position. We'll leave it for the minimum number of days, 10 days. We'll receive maybe 10 or 15 applications. We can't see the stuff. We get the applications close. Then we're told who qualifies for the position. That usually knocks out a couple of people. Let's say it knocks it down to 10 or 12. We'll reach out to people. By the time the 2 or 3 days after they qualify, we'll have reached out to all of them. Maybe 2 or 3 of them are already not interested. They've taken a job somewhere else. So we're down to 6 or 7, maybe 8. By the time we interview them, 3 or 4 days to interview them, by the time we interview them, usually 1 or 2 people have already dropped out. We take 1 or 2 more days just to figure out who we want to hire. This is less than a week and a half time period. We find out there's probably 3 people left after we've done interviews, figured out who we wanted to hire, and tried to offer the jobs. And in large part, we're offering jobs to people who have already taken a job in that 2-week period. We just cannot move fast enough. And whatever we're offering and whatever they think we can offer them is apparently not enough for them to hold out versus the other jobs that they're taking. So we're trying to really look at doing things as fast as possible, but we're turning things around in a half a day when we're trying to hire people. We're trying to interview in less than a week, 3, 4, 5, 6 people. Hopefully we find a couple of solutions in there, but I just can't give you a single, a silver bullet issue as to the reason why we're having turnover that we can necessarily fix.
Do you see in terms of the turnover rate and in terms of the time that it's taking you to interview, what do you see are are the hindrances there? Is it lack of current staff? Is it more along the lines of the workload that you have? What do you see?
Yeah, and
in
I don't even think it's taken us that long to interview. I think by the time we get applications, we're trying to interview every single person and come up with who the candidates we think we should offer the job to are. We're doing that entire process in maybe 3 or 4 days, trying to do it in 3 or 4 days. But to your point, yeah, that 3 or 4 days, we're pulling off people that we need that are working on cases, that are trying to get things out the door in a statutory time period. We're pulling those people off those cases and working around their schedules to try to set those interviews up. And it's a confluence of different things, but that's certainly one of them that when we have so few resources historically, you're either working on a case or you're doing something different. But if you're interviewing someone on an interview panel, then that's work you can't be doing on these cases that we all have statutory deadlines for.
Thank you, Mr. Chairman.
Thank you, Representative Hall.
Thank you, Mr. Chairman. Thank you, Mr. Chandler, for your testimony today. I learned a lot. Representative Lockett, this is at least the second time you have taken one of my questions, so I don't know if that's scary for you or me, but along the same lines there, I was going to ask about your turnover and some of the challenges you've had there, and you've kind of addressed that already. So I do want to go to another question or point I had. So I have several constituents in the Lansdowne neighborhood area and others who have been very vocal about their concerns with Kentucky Utilities and their tree cutting measures. And historically, the neighborhood association worked directly with Kentucky Utilities on selecting the types of trees they would plant in this median that they managed as an association. And then Kentucky Utilities unilaterally changed their own guidelines or regulations around what types of trees and how they were going to maintain those trees. And those trees that they decided to cut down in that utility were nowhere near in danger of getting anywhere close to the power lines. And despite a lot of public pressure and the mayor in Lexington getting involved, eventually they went on and clear cut a lot of the trees in the median. Now, they did a decent job of going back and replanting new trees and making it look presentable for the constituents and people that lived in that neighborhood. But I have several folks that are upset that we, the legislature or the Public Service Commission, could not prevent that or make Kentucky Utilities even adhere to their original regulations that they had on, the books in the past. Is there any role that PSC could have in the enforcement to keep them and other utilities whole when it comes to that sort of issue?
So is there any place that the PSC could do which part?
To keep Kentucky Utilities and other utilities to prevent them from clear cutting trees when it's not necessary.
Yeah. So you say not necessary, right? And that becomes the issue of fact. So none of this has ever been put in front of the commission, but the determination as to what is or isn't necessary is going to be a factual determination. And unless somebody puts a complaint in front of us, as a general matter, no. It's not strictly adhered to in Kentucky, but generally there's a broadly applied across in other states this business judgment rule as it relates to utilities that look if they're and it may be outdated yet, it may not even be necessarily applicable, but there is an idea that look, the utility is under a service obligation that they have to provide adequate, efficient, and reasonable service. If they go out and do things to endeavor to meet that minimum standard, whether their actions to meet that were reasonable or the practices that they took were fair, were reasonable, that's spoken to in our statute. If somebody can allege that, if somebody can prove that, or they could file a complaint that says, look, this practice is not reasonable, the statute already provides for that. But whoever's alleging that has the burden of proof to show that the practice of the utility, and I'm sort of talking off the cuff, I'm not really prepared to. I haven't done the legal research in a long time on this, but effectively the individuals, the people, the public would have the legal burden to show that whatever practice that the utility is employing and trying to meet their statutory standard was unreasonable. That is the mechanism that has existed under law for decades and decades and decades. But it is a factual determination as to whether these were necessary actions or whether these were unreasonable actions. And until that's in front of the commission with all the evidence in front of it, we've not really, spoken on this. We've not taken a position on it. But big picture on anything that kind of sounds like this, big picture, that's how it'd have to be dealt with.
Thank you.
Thank you. We've got, excuse me, we've got about 4 minutes left, Senator Boswell.
On the outsourcing, under the attorneys, well, that's the question. I'm sorry. The question I had was about the loss of so many attorneys. Does the Public Service Commission currently outsourcing that legal work?
Yes and no. So we don't for our ordinary attorneys. We have gone out, and a few of the members of this committee are aware of this, and they'll be more aware tomorrow during Chairman Smith's meeting. But we have gone out. We've tried. We've gotten an attorney once to try to help with the citing board, the influx of those merchant cases. That was one attorney, but we don't have that now. Everybody that we're using for the citing board, those attorneys are all in-house attorneys. And we have gone out, and I think the contract expires at the end of this month. We did go out and hire an attorney who, a law firm that exclusively does legal work at the federal level, at the Federal Energy Regulatory Commission, to represent the commission in a couple of cases up there, primarily related to the proposed transfer that now resolved, didn't go through, but the transfer or sale of Kentucky Power from AEP to Liberty. We did go out of house so that we would get experts that only practice law at the federal level, so that we made sure that we had the appropriate expertise and that we were successful there.
Thank you, Mr. Chandler.
Commissioner Chandler, thank you for being here today. And any other questions? All right, I think my comment on I appreciate what y'all do. Obviously, in East Kentucky, we feel like the rider cost that we have to pay for on the demolition of the power plant, the coal-fired plant, has been detrimental to us, really. Again, this is a broken record, but I thought the lady that I talked about in our church was 74, but she's 79, and she lives in a mobile home, and her electric bill in the winter was $500-600, and she only draws $652, I think, a month. And paying, I mean, if we ask the question, are the electric rates a lot higher now than they were 10 years ago? The actual electric rate may not be that much higher, but all those demolitions and buying another power plant to take its place, I feel like it's unfair because the investors, and I think I'm right, Kentucky Power's investor owned. The investors, they reap the benefits of their investments. They don't have to face the consequences. Basically, what I'm saying is when the coal-fired plant was destroyed, did the investors also have to pay part of that? No, it went all to the ratepayers. And so the investors, they win. They're a win-win-win situation. Our people in the mountains, it's just not fair to them. And that maybe that's nothing you could change or the Public Service Commission could change. But in our minds, the people of East Kentucky, we're paying for something. We don't have any say-so in it. The ratepayers is what I'm saying. And so anyway, if there's anything that we could do as far as looking at reliability in the coal-fired plants and in the equation of are we going to destroy coal-fired plants, or are we going to, because natural gas is not coal, solar is not coal, there's not anything out there that's coal. We still have a lot of it in the mountains. It just ain't fair for us, the ratepayers, or for my people, the ratepayers, to have to pay extra when in investors they win any way they go.
Yeah, and so I know that wasn't so much of a question. Senator Smith's rubbing off on you, but I just make one statement, and I hope it kind of came through the presentation. I'm in the seat. I'm just keeping the seat warm, right? I mean, I don't mean it like we're all here temporarily, right? None of us are going to do this job for the entirety of the job. There were people that sat as chair of the commission before me, and there are people who are going to sit in this chair after me. But the commission is still going to be there, and it's still going to be necessary. And there really are long-term detrimental effects to the economy of the Commonwealth and to our individual consumers for an under-resourced public service commission, a public service commission who doesn't either have the opportunity to do its job well or, frankly, doesn't do its job well. And that's why I've been a significant advocate for making sure that we have the staff that stays there even as commissioners rotate in, so that some of the decisions the commission makes impact the Commonwealth for 20, 30, 40, 50 years. And we can't afford to have multiple mistakes across the board that last that long. And so I just really appreciate you giving me the opportunity to talk about how important I think that the Public Service Commission to the Commonwealth. I always call it the most important state agency that no one knows about, because it does. Everybody pays a power bill. Everybody pays a water bill.
Right.
And so I just really appreciate the opportunity, because I think that long term, for the benefit of the entire Commonwealth, a strong PSC is necessary.
Thank you, sir. Senator Smith, final comment?
Yeah, and we'll just take it up tomorrow, but I think that there'll be a lot more discussion based upon what the chairman had said about the changes of what happened with this Liberty deal moves into the rearview mirror and we go forward. And I think there's a possibility on the table for us that I'm very hopeful about. And so I think it could turn into something very, very positive, and I will give you a lot of credit for that, because I think you've been at a very strong presence at the wheel with the Public Service Commission to hold all these utilities accountable. Good, bad, and indifferent. And I think for those of us that are concerned about these rates, that having that type of leadership over there bodes well for us with what's coming. So let's leave it at that.
All right. Thank you all for coming today. We will be adjourned. The next meeting is scheduled for Wednesday, July the 19th, and Chairman Boswell will be at the helm of things.